Hello, my name is Patty, and I'm going to walk you through Section 7118A4A of the Federal Service Labor Management Relations Statute. This section provides information on the time period in which an unfair labor practice, a ULP, must be filed to be considered timely. If a ULP is not timely, it is subject to dismissal, even if the charge has merit. The statute provides a time period in which a party must file a ULP charge for it to be considered. In this video, we will be discussing the 6-month filing limit and the conditions under which someone may have additional time. There are other time limits in the statute, however, this video only covers the limits for filing a ULP charge. Section 7118A4A states that a ULP charge must be filed no later than 6 months after the alleged unfair labor practice occurred. This is known as the 6-month rule. How do we know the date when the unfair labor practice occurred? The authority examined this question in the Great Lakes Science Center case. The agency argued that the 6-month statute of limitations period began on April 26, 2012, the date it announced a change in travel reimbursement rates. However, the authority held that the 6-month time period began on May 15th, the date the change was implemented. The difference between the two dates is critical because the charge was filed on November 15th, exactly 6 months after the May 15th implementation date. Because the statute of limitations clock began ticking on May 15th instead of April 26th, the authority held the charge was timely filed. In arbitration cases, some awards include time periods by which a remedial action must be taken, but many do not. To determine whether a charge alleging noncompliance with an award is timely, the FLRA looks at whether the charged party has expressly notified the charging party that it will not comply, or, if there is a deadline in an award, whether that time period has passed without the charged party taking the remedial action. But what about situations where a party doesn't find out about an alleged unfair labor practice right away and is not able to file a timely charge? Section 7118A4B provides some exceptions to the 6-month rule. This section can be used to extend the time limits for filing a charge in two specific situations: when the charged party failed to perform a duty owed to the charging party, and when the charged party concealed its violation from the charging party. However, this section applies only when the charged party prevented the charging party from discovering the unlawful conduct within the 6-month limitation period. I will provide some examples on this later. Let's talk about the first exception to the 6-month time limit, the failure of a party to perform a duty owed. For example, let's say an agency makes a change in conditions of employment for which it has an obligation to provide prior notice and an opportunity to bargain, but it doesn't notify the union or bargain over the change. The union does not find out about the change for 8 months. Because the agency had a duty to provide notice and bargain prior to implementing the change, and the union first learned of it 8 months later, the 6-month time period began on the date the union found out about the change. Had the union found out about the change 5 months after it was implemented, the union would have had to file before the end of the 6-month period. The union does not get an additional 6 months. The failure to perform a duty owed exception is discussed in Customs and Border Protection El Paso, where the authority found a charge to be timely based on the agency's failure to provide adequate notice of a change. The second exception in 7118A4B applies if the alleged unfair labor practice was concealed. Concealment involves an action that is initially unknown to the charging party and is discovered after the 6-month limitation period has passed. Several authority cases have considered concealment as part of its analysis of a duty owed to the charging party. There have been some cases where concealment is discussed on its own merit, but the authority found no concealment. In those cases, the authority looked at the evidence to determine whether the alleged unfair labor practice was concealed. In IRS Houston, the agency made a change to its dress code prohibiting the wearing of jeans. The union argued it was not aware of the change within 6 months of its implementation, but the judge found, and the authority agreed, that the union was not prevented from filing the charge within the 6-month statute of limitations. The agency held several employee meetings where the dress code was discussed and to which the union was invited, and management also discussed the coming changes with the union in the months leading up to its implementation. Let's look at some examples applying the section to determine if a charge is timely. In the first, the agency implements a change on February 15th. The agency did not provide notice or an opportunity to bargain prior to the change. On August 30th, the union learns of the change, and the union files a ULP charge the next day. Is this charge timely? Yes. The agency implemented the change without bargaining on February 15th. 6 months from February 15th is August 15th, normally the 6-month filing deadline. However, the agency allegedly failed to perform its duty to notify and bargain with the union over the change, and the union did not discover the change until August 30th. The statutory 6-month time period for filing begins on August 30th, so the August 31st charge is timely. In another example, the agency implements a change on February 15th without notifying or bargaining with the union. On July 30th, the union learns of the change and files a ULP charge on August 31st. Is this charge timely? No, in this case, it's not timely. What's the difference? The difference is the date the union learned of the change. In this example, the union learned of the change on July 30th, which was within the 6-month filing deadline of August 15th. Thus, the union had to file a charge by August 15th for it to be timely. The statute does not give the union an additional 6 months to file the charge. Remember that Section 7118A4B only gives the charging party an additional 6 months if the charging party does not find out about the alleged violation within the initial 6-month period. Sometimes, in their collective bargaining agreements, parties include steps they must follow before filing a ULP. For example, if the parties require a 15-day notification period prior to filing a ULP, that contractual requirement does not change the 6-month statute of limitations. So, using the previous example, let's say a CBA requires a party filing a ULP charge to give the other party 15 days notice. If the agency implements the change on February 15th, and the union learns about the change on July 30th, the deadline for filing a charge is August 15th. If the union is required to give the agency 15 days notice, it must notify the agency no later than July 31st, so it can still file a timely charge by August 15th. Nothing in the party's contract can toll the 6-month statute of limitations. The timeliness of a charge is an affirmative defense. This means that the charged party must raise this issue before the close of a ULP hearing or the charged party waives this defense. Although it is an affirmative defense, regional directors will generally dismiss charges that are clearly untimely before the case gets to the complaint stage. Thanks for watching this video detailing unfair labor practice timelines. For more information, please visit us online at flra.gov or contact your nearest regional office. As well, a survey link is in this video's description box. We'd appreciate your feedback.